Now, I am going to dictate a legal passage based on latest Supreme Court judgment at the rate of 120 words per minute. Let's start.
The learned counsel for the appellant has placed reliance on the decision of this court by a bench of which one of us within bracket Justice Virjes Kumar was a member in Mohimbur Rahman versus State of Assam within bracket 2006 SCC 715 for the proposition that the circumstance of last sin does not by itself necessarily lead to the inference that it was the accused who committed the crime. It depends upon the facts of each case. In the decision relied upon, it has been observed that there may be cases where, on account of close proximity of place and time, the phantom of death, a rational mind may be persuaded to reach an irresistible conclusion that either the accused should explain how and in what circumstances the victim suffered the death or should own the liability for the homicide. The present is a case to which the observation as aforesaid and the principle laid squarely applies, and the circumstances of the case cast a heavy responsibility on the appellant to explain, and in absence thereof suffered the conviction. Those circumstances have already been noticed in which case such an irresistible conclusion can be reached will depend on the facts of each case. Here it has been established that the death took place on 20th March between 3 and 4 p.m. It is just about that much time that the appellant and the deceased were last seen by PW1 and PW11. No explanation has been offered in the statement by the appellant recorded under Section 313 CRPC. His defense is of complete denial. In our view, the conviction for offense under Section 302 and 376 has been rightly recorded by the Court of Session and affirmed by the High Court. Para. We have noticed the decision, however, the circumstances in the present case are not similar to the case where the event of the last scene together has very close proximity with the time and place of the commission of the crime, and other circumstances also favor the hypothesis of guilt, and consequently the fact that no explanation or false explanation offered by the accused was taken as a link in the chain of circumstances. She also Birbal versus State of MP within the 2010 SCC 212 Raju versus State of Haryana within the 2001 9 SCC 50 and Babu son of Robi versus Babu son of Babul, and another within the 2003 A7 SCC 37. Thus, in the circumstances of the case, the accused persons not giving any explanation in their examination under Section 313 CRPC could not be taken to be a circumstance pointing towards the irresistible conclusion that they are involved in the commission of the crime. Para. In the light of the factors that evidence regarding the recovery of the incriminating materials from the accused persons has been discarded, that there has been sufficient time gap between the instances when the accused persons were last seen together with the deceased persons, and in the absence of any other corroborative piece of evidence to complete the chain of circumstances to fasten the guilt on the accused couple, we are of the opinion that the accused have been rightly given the benefit of doubt by the courts below. We have found that the finding of the High Court that the chain of circumstances is not complete to conclusively established that either A1 or A2 alone or with the common intention of each other have committed the dreadful crime of murder of a newly married couple is correct, and merely suspicion However, grave cannot replace the weight attached to the evidence. Accordingly, we order for dismissal of the appeal. Stop. Thank you.